ready.
Yes. All right, Mr. Gardner had a chance to review this opinion in Whittingham, which you indicate may affect your opinion.
I don't think it significantly affects the overall conclusions in our opinion.
We'll talk about that further in a little bit. I just want to kind of get your, now that I've had a chance to review it, be able to ask you about it. It appears that it dealt with a dissolved partnership.
Yes.
There's a different statute for partnerships than for corporations.
Agreed.
Right? This particular partnership, while dissolved, borrowed money and used it to pay a lien on one of its assets, real property.
That's how I understand the facts to read too.
The real estate was in the name of the dissolved partnership, and the dissolved partnership purported to give a deed of trust to the lender. Is that how you read it also?
Yes, that's how I read it.
And then after the dissolved partnership received the funds and paid them over to someone else, the lender wanted to foreclose its lien against the real property. Is that, am I reading that right? Your understanding too?
I think so.
And the court held that the lender could not foreclose because the transaction under which the dissolved partnership borrowed the money and gave the lien was void because the transaction occurred while the partnership had been dissolved or after its dissolution.
Basically, yes. Agreed.
And while this decision specifically dealt with a partnership, the ruling was based upon a Utah Supreme Court opinion relating to dissolved corporations.
Right, the Houston opinion.
And the Utah Supreme Court held that contracts entered into by dissolved corporations are void in Utah, no matter how inoffensive the subject matter.
That's what the case says.
Previously, so this opinion in Whittingham comes from the Utah Court of Appeals, which is a lower court from the Utah Supreme Court.
Yes.
And previously, as cited in both your opinion and the Snell and Wilmer opinion, the Utah Court of Appeals in Orvis versus Johnson had held that contracts entered into by dissolved corporations are merely voidable at the counterparty's option.
Right.
But the Court of Appeals is disavowing its prior decision in Orvis in this new opinion in Whittingham.
That's how I read it.
And it's doing so because it determined that the Utah Supreme Court's opinion in Houston has never been overruled.
Yes, exactly. That's what it says.
And the Utah Supreme Court in Houston held that contracts entered into by dissolved corporations are wholly void.
That's what it says.
Which I take would, all right. Void meaning they're never enforceable, I think is what,
That's what I think void means. They're invalid
from the beginning.
from the beginning.
Just as Ms. Jarvis testified that acts taken in violation of the bankruptcy state are void from the very beginning. This new opinion you've brought to our attention indicates that contracts entered into by a dissolved corporation are void from the beginning.
I think it's worth noting that that partnership had been, I think it says it was dissolved in 2007, and that this contract, this loan was entered into over 2 years later. So
After
the period in which it could have reinstated potentially as a partnership.
Now, the Houston opinion was rendered in 1919. You have to give her answers.
Yes, it was.
Thank you. What is your opinion on the section 1405 postdates 1919, so that legislation was enacted after the Houston opinion. What is your opinion as to the effect of the legislature's enactment of section 1405 on the Houston ruling?
Well, I believe that the statute's important and the statute matters and has to be dealt with. And so, I believe that whoever's looking at this again and dealing with the statute, which this case doesn't deal with, because doesn't deal with the corporate statute. If a case comes up again later in which 1405 comes up, it's going to have to be an issue to be dealt with.
I would.
If I understand correctly, it's a question of void or voidable, or that's one of the issues.
Yes.
And what would be your guess as to, because you seem to say, we don't know, we have to wait until the issue comes again.
So my personal opinion is that if this issue came before a court having to do with a dissolved corporation, and that was involved in the process of liquidating and winding up its affairs, and under the statute which we have before us, which allows it to do things like collect its assets and dispose of its properties, that the court's going to permit that corporation to dispose of its properties. That's my personal opinion, but that hasn't been addressed in the courts yet.
But what about the contract that the company is not allowed to do? Would they be considered void or voidable?
I think they would have to be allowed to enter into contracts to dispose of their assets. I do think that, in which case they either would be valid contracts or at a minimum voidable contracts, but not void.
What about, maybe it's not, these cases are not relevant to what I was going to ask, but I ask it all the same. What about contracts there are still contracts that the company is not allowed to enter into? There are. I mean,
Yeah, there certainly are contracts they can't be allowed to enter into. Those ones would be void.
Those would be void.
Yes.
Okay.
And by the way, my views are separate from the fact that this is the law that's come down, and the law is what it is now, that apparently we have to deal with the fact that we have a case that says these contracts are void. I mean, my view is one thing, and the law that we have to abide by says that these are void.
Thank you. Sorry.
No, I want to follow on that line of questioning. We take this opinion, and in particularly the Houston opinion, and we compare that to section 1405. I think, if I understand what you're telling us, your opinion is that once this is revisited by the Utah Supreme Court, your opinion is that it's likely the Utah Supreme Court would determine that contracts which are entered into and which are not in furtherance of a winding up and liquidation would be void. Is that right?
Yes, that's right.
But that contracts entered into by a dissolved corporation which are in furtherance of winding up and liquidation will be at worst voidable. Is
Yes,
that right? And could and very well be enforceable.
possibly.
So those would be the limited, when I'm reading this opinion, paragraph 7, in Whittingham, it says, refers to limited circumstances in which the contracts of a dissolved partnership would be valid. Your opinion is that if the Utah Supreme Court revisits this issue with regard to corporations, that the limited circumstances set out in section 1405 could be those that are valid contracts.
Well, that, my opinion is that's what I think the court ought to do. Whether that's what the court will do, I have no idea.
Who would have thought the Utah Court of Appeals would have done this?
I was surprised by this.
Paul. The elements of a contract under Utah law, they require an agreement and consideration. What are the- Oh, more than one party, an offer and acceptance and consideration. Is that right?
That sounds familiar.
If you take a look at tab in your binder bundle, tab 6, which is C57.
I have it.
And this is the joint resolution, and I
Yes.
simply want to confirm, have you confirmed that it is signed by more than one. Say joint, so it is signed by the directors of both the dissolved entity and the 2005 entity.
That's what it says.
That concludes my question.
Yes, I have just a question. How do you draw the line between contracts in furtherance of winding up and the ones which are not in furtherance of winding up? Could you elaborate a little bit on that?
Certainly. A company that's dissolved has one purpose, and that's to wind up its affairs. That's to cease operations and extinguish its assets so that all of its liabilities can be paid, and if anything, any assets remain after that, those can be distributed to the owners of the business, and then it can stop doing anything at that point. So liquidation and that's liquidation, and the process of winding up is the process of doing just that, of taking actions to cease operations and to extinguish assets. So that's what we focus on. So there's a variety of things that can happen, but most typically, a company that's dissolved will find ways to sell its assets. And that's primarily what it will do. And then use the proceeds to pay creditors, and hopefully at the end of the day, there's something left to pay shareholders.
So for example, transfer its assets to another company could or could not be in the winding up process?
You could transfer assets, in my view, to another company if you receive valid consideration for those assets. Because if that would be disposing of those assets in a manner that's consistent with Section 1405, which is our dissolution statute.
And I would just add that when disposing of those assets, then the monies that you get would be distributed to the creditors of that company, and if there's anything left over to its shareholders.
But I guess there are borderline cases where you have to decide whether it's for the purpose of winding up or not, I imagine. Or is it quite clear cut?
Sorry?
Is it quite clear cut, or are there some contracts that could be seen as in furtherance or not?
Okay, I think it's pretty clear cut. For example, in my view, a merger is something different from winding up a corporation, because a merger actually is a means by which the business of a company is continued, and it continues on rather than ceasing operations and ceasing the process. A merger, that's what that does. So a sale of assets is different from that. So I think it's actually pretty clear cut. It's pretty easy to decide, in my view, what is a transaction that is in the process of liquidating and winding up a company versus what isn't.
Thank you, that clarifies.
Are you done, Greg?
Yeah. Apologize. Belmont has questions. Oh, sorry. Sir, I just want to make clear, I'm in the context of the opinion you expressed, not what the law says. Even as now, that your opinion, as I understand it, is that a dissolved company can dispose of its assets as long as it's for winding up purposes, and that is, you say, best or worst, I don't know how to qualify it, voidable, correct? Is that how that's how I understood it?
I think that under this case that we've just been talking about, that there is risk now that a court would say somehow that even that type of a transaction would somehow be void. I think that's what the case says. What my personal opinion is that what should be is that a corporation should be able to dispose of its assets consistent with the statute, and that if it is doing so in a manner that's consistent with its mandate to liquidate and wind up its affairs, then at best such a transaction or a contract entered in that situation would either be enforceable or at worst voidable, but shouldn't be void. That's my opinion.
That's how I understood it. That's
Okay.
how I understand. Within that context, you would put, I think, a question, and you clarified what the law says about dispose. You said dispose, basically, as I understand it, sell, and certainly not merger. Is that correct?
That's my view, yes.
And if you cannot merger, you cannot close on a transaction to purchase, I guess. That's even worse. You would agree?
Sorry, say that again?
If you cannot, you can only dispose, and dispose is not merger, then even less can you buy or close on something. To purchase,
You could, it's, yes, I guess the answer to your question is buying an asset after you're dissolved would be inconsistent with liquidating and winding up. I would point out though, when a company is administratively dissolved, there's a 2-year period in which that company can be reinstated. And the statute says, that a different statute than 1405, I think it's 1422, says that if a company is reinstated within that 2-year period, then all actions taken from the date of the administrative dissolution until that reinstatement, those actions are ratified and completely valid. So that creates a question that actions taken immediately after administrative dissolution and for the 2-year period thereafter certainly can be ratified and made valid if the company does a reinstatement.
and what about within your scenario, if the purchase was intended for purposes of continuing purpose for majority shares and continuing investing and managing the company, would that change your answer to your?
It wouldn't change my answer if the company did in fact what's the word, get reinstated as a valid corporation. But frankly, if it did anything in that 2-year period and was reinstated, any action it would have taken, whether it was for dissolution or for anything else, it would by the statute it would be a valid action.
Okay, and I'm still within the context of your opinion and not the court decisions. Take the scenario that it's a dissolved company after being dissolved, disposes, enters into a contract to dispose of its assets, and assume that that is voidable. And my question is, who's the aggrieved party? Is the only the aggrieved party can ask for performance, correct? It's only the aggrieved party.
There's only the aggrieved party who could seek to ask a court to say, I want this contract to be voided.
Thank you.
Good afternoon, Ms. Jarvis and Mr. Gardner. Mr. Gardner, let me start with you. The new opinion that you brought to our attention today, do you think that strengthens the conclusions you reached in your report or weakens them?
Overall, by the way it reads, strengthens.
Why do you say that?
Well, because my portion of the report focuses on the merger and whether a merger occurred or not. And if we assume, for sake of argument, that a contract was entered into for a merger, this case supports the conclusion that that contract would be void.
And you had other reasons in your report to conclude that it was
Yes.
void, but this provides you an additional reason. Is that how I understand your answer?
My answer is that it provides an additional reason that I wasn't aware of when we wrote the report because the case hadn't come out.
Now, one issue is, of course, the merger, the alleged merger. The other issue is, as you well know, in this case, there's an issue of the transfer of a 57% interest pursuant to an SPA signed and dated March 2001. Does this new case, in your view, apply to a transaction like that, or do you think there are differences
I
with
think
that
that,
type of transaction
Well, I do think
as to
there-
what was at issue in the case?
I do think there are differences in that, in this case, meaning the present case, the March 27th contract preceded the administrative dissolution of the 1985 company, or EuroGas 1 as I call it. And then EuroGas 1 was administratively dissolved on July 11th,
I see.
2001.
So, in the new case, that you cited today, the contract was executed after the company was dissolved.
The contract was executed before.
Sir, I think you meant in the case, the new case.
Oh, sorry.
That's the-
Yeah,
the-
that's
the
correct, that was my
case.
question. In the new case that you brought to our attention today,
Oh,
there
my
the
apologies.
contract was executed after the company was dissolved. And not only that, it was also,
Well, that's an argument, not only that, but also, and also you
it's a
have to.
statement of fact.
You know, there is a problem, Mr. President, because that sale purchase agreement does not really arise. I didn't mention this, but it's a sale purchase agreement. So I have no objection that my learned colleague mentions that, but then has to characterize it carefully, accurately, meaning a contract entered before the company was dissolved, but not closed at the date of when the company was dissolved. So I have no objection, but you have to adequately define the chronology of the events in a non-leading way.
Mr. Gardner, with respect to the SPA,
The March 27th SPA.
what do you understand to be the relevance of March 2001?
March 2001 is when I understand the SPA was, that's the effective, March 27th, 2001 is the effective date of the
Do you
SPA.
know whether that contract was signed before EuroGas 1 was dissolved?
My understanding is it was signed before EuroGas was administratively dissolved.
In the new case you brought to our attention today, was the contract at issue signed before or after the company was dissolved?
It was signed after the partnership was dissolved.
In the new case that you brought to our attention today, was the contract signed before or after the 2-year period for which the company could seek reinstatement had expired?
It was signed after 2 years.
And going back to some of the questions from the tribunal, is the fact that in the new case you brought to our attention, the contract was signed after the 2-year reinstatement period relevant to your assessment as to whether this ought to be the law or not, or how issues like this might be considered in the future?
I think it is relevant. I think it's relevant in the sense that I think it's unclear how a court would deal with a corporation or another entity that A, has entered into a contract before it was dissolved, but perhaps not fully performed, or B, entered into a contract or during the 2-year period in which it could be reinstated. The present case, or other cases that I'm aware of, don't deal with those facts.
You have noted that in your own personal view, the court perhaps should have reached a different conclusion. Is this now binding law in Utah, notwithstanding your opinion on that issue?
In my view, it is binding law.
You were shown a document just a moment ago, which is at tab 6 of claimant's bundle. It's the joint unanimous consent resolution C-57. You've read this document?
Yes, I have.
In your view, you note that throughout the document they use the phrase Class F reorganization. My question is whether a Type F restructuring, as the claimants use that phrase, can merge two corporate entities.
No, can't.
Objection, we did not ask him questions with regard to Class F and merger. It's outside the scope.
It's okay, I have the answer.
Yes. That's fine.
In your view, Mr. Gardner, does this joint unanimous consent resolution merge two corporate entities?
Objection, outside the scope.
Mr. Chairman, the witness was asked specifically about this document, and there's no question that one of the issues in this case is whether it in fact merged the two corporate entities. You'll recall the witness specifically said that it required an instrument of transfer, and one of the issues during that cross-examination was whether this was such an
You
instrument.
can have the question.
Thank you. In your view, Mr. Gardner, does this joint unanimous consent resolution effectuate a merger?
No.
Why?
This joint resolution reflects the intentions of the two boards of directors to do something, to in essence combine the two corporations and make them into one without complying with the merger statute or without at least providing evidence of actual transfers of assets or contractual assumptions of liabilities. And it also contemplates that the new EuroGas entity would simply treat the outstanding shares of the prior EuroGas entity, or EuroGas 1 as I call it, simply treat those shareholders as its own, which in my experience as a corporate lawyer, I don't know how you do that. You can't, one company can't just, by a resolution, by the way, the directors are the same on both sides, right? Decide that the shareholders of one company are now the shareholders of another company. That just doesn't work, at least in Utah corporate law.
How do companies merge in Utah?
They enter into an agreement, usually called an agreement and plan of merger, and then they agree to file articles of merger with the Division of Corporations, and they file them. The public, it gets notice of the fact that these corporations have merged, and then the merger is effective once those articles of merger have been filed.
So the merger cannot take effect before the articles of merger are filed?
No.
Mr. Jarvis, I think I'm going to turn to you now. Ms. Burton took you through hypotheticals concerning Jarvis Court. Do you recall those?
Yes.
Could you tell us why you think this case is different than the hypotheticals Ms. Burton gave to you?
Well, I think, as we said, particularly in the rebuttal opinion, this is a case of a corporation that was dissolved and after 2 years could not be reinstated, then filed bankruptcy. It filed bankruptcy, it did not file any statements and schedules, and under bankruptcy law, then nothing, no assets could have been abandoned and could be within that the corporation's control after the bankruptcy had concluded. So there would be nothing to administer at that point.
And this may be a question for Mr. Gardner as well, but since it does bear on bankruptcy, I'll ask it to you. Could a merger operate executed after a bankruptcy had concluded, but that purported to apply retroactively during the bankruptcy? Is that something that could be valid in Utah?
I think Sam has stated that under Utah corporate law, you cannot have a retroactive merger. It has to be at the time that the articles of merger are filed. And if you're asking for something to come in effect at the time the automatic stay is in place, that would be void. Any act taken in violation of the stay is void ab initio, absolutely void.
Now, In her questions today, Ms. Burton focused almost exclusively on the EuroGas GmbH, the Austrian entity. Are there other assets or interests you know of owned by EuroGas concerning this whole project, aside from EuroGas GmbH?
Well, my understanding from reading the SEC documents is that, that there is an issue with respect to the 57% that was bought from Belmont. And while I can't opine exactly when that, that was transferred, because that would be a subject of Canadian law, which is what would determine when it was transferred. But as I explained with other assets of the estate, if at the time of the bankruptcy filing, under Canadian law, which is what you would apply, this was an asset of the estate, then it would become property of the estate at that point in time.
And do you know whether that, if that 57% was transferred, it would have been held directly by EuroGas One or through GmbH, the way the 33% was?
My understanding is it was directly by, again, from reviewing the SEC documents and public filings.
There was also some discussion about how causes of action that may arise after a bankruptcy is commenced can relate back to an existing asset. I just wondered if you could provide a bit more of a fulsome explanation about how that actually works.
Right, because there are some causes of action that arise that are property of the estate that aren't directly connected with another asset. One of the examples would be the Stevens case, which was decided by the district court in the District of Utah. So the court that is the appellate court and the court of original jurisdiction for the bankruptcy court in Utah. In this case, the Stevens case, the court was actually applying judicial estoppel, meaning can this claimant actually bring this claim in their court? But in doing so, they interpreted and had to interpret what was property of the estate. And the facts of the case are such that the claimant had an employment claim, but that claim didn't arise until after she filed the Chapter 7 bankruptcy. However, before she filed that bankruptcy, there were clearly issues that had happened that she thought it was a possibility that this could be a claim at some point in time. So at the time she filed the Chapter 7 bankruptcy, she knew that there could be a claim that would arise, and that claim actually didn't arise until after the bankruptcy was filed. She did not list this on her statements and schedules. And so the district court looked at whether that was an asset of the bankruptcy estate and found, again, interpreting the potential claims that from decisions of the 10th Circuit, in that case, they looked specifically at the policeman case, said this is a potential claim and was a potential claim at the time of the filing of bankruptcy. Should have been listed as an asset of the bankruptcy. Because it was not listed as an asset of the bankruptcy, it was not abandoned, and it could not be pursued by her. And in addition to that, she was judicially stopped, meaning because she took a position that this didn't belong to her in bankruptcy, she could not now say that it belonged to her thereafter when she sued.
And again, this might be a question for either of you. Ms. Burton raised the question about share transfer. Mr. Gardner, I think you replied that as winding up activities, a dissolved corporation could sell its assets and receive back the shares of the buyer. Could you tell the tribunal why you think this case is different from that scenario, if you do think it's different?
Well, in this case, there was no actual issuance of any shares by what I call EuroGas 2 to EuroGas 1. There was just a statement that it would deem the shareholders of EuroGas 1 to be the shareholders of EuroGas 2. And like I said before, that's not a concept that makes any sense to me under US or Utah corporate law. That's not a valid way to acquire shareholders or to issue shares.
Ms. Jarvis, one of Ms. Burton's questions to you revealed that there are two cases on which you would rely for a particular proposition. Counsel can correct me if I'm misstating this. One of them relied on a prior statute and one of them relied on a current statute. And I noted in the claimant's reply memorial, there seemed to be some suggestion that you had relied on an incorrect statute. Could you just address that for the tribunal?
You know, the two cases were cited in the original opinion to talk about mergers and whether mergers could happen beyond the 2 years of reinstatement. And the law did not change with respect to one or the other, and so it didn't matter that they were under the old law or the new law, because under both laws, the time for reinstatement, there was a period of time where it used to be 1 year, but then it became 2 years, and during that 2-year time is the only time that a corporate can reinstate. Once it passes that 2-year period, it cannot reinstate. And that's the same under both laws.
And so in your view, is the fact that one case relied on a previous statute relevant?
No,
Why?
because again, the law hasn't changed with respect to a merger. Can a merger occur beyond the 2-year period? No, it cannot. The only thing that changed was the wind-up period beyond that, where you can not merge, but where you could sell off other assets. That was the time period was taken from that. But there is actually still, because one of the cases is a new case under the new law, still the issue that there is at some point in time a time where the wind-up period cannot go beyond. So I think the Hillcrest case, which I believe is under the new act, said 10 years after the company was dissolved, too late to now raise and try to pursue an asset. So at some point, it would be an equitable standard, but it's too late to even pursue wind-down activities. They have to complete that cycle.
Mr. Gardner, I don't know if I've already asked this question, so I'm sure I'll be told if I have. You had noted before about statutory merger. Is there any other way to merge in Utah lawfully?
I am not aware of any other way.
I prefer. Keep it open.
I am not aware of any other way.
Ms. Jarvis, a number of the questions asked you by Ms. Burton concern trustees' control over property and abandonment. Does the trustee have complete control over whether property is abandoned?
No, there are, under the abandonment statute, there are 3 ways that property can be abandoned. The first is the trustee can file a motion to abandon or a notice of abandonment. But the Cook case, the 10th Circuit case cited in my opinion, very, very clear that the trustee has to be precise about noticing what asset is going to be abandoned, given notice to all the creditors, give them opportunity to object before an asset can be abandoned. The second way that an asset can be abandoned is another party, not the trustee, can ask that the court order the trustee to abandon the asset. That can be done, but again, it has to be done by motion. There has to be notice given to parties. There's a rule 6007, that makes it clear that these have to be noticed because they're serious issues that the court has to decide. The third way for assets to be abandoned, very, very clearly, they have to be scheduled. So they have to be filed in the statements and schedules. And then the trustee has to have not administered them during the bankruptcy case. And then when the case is closed, then they are abandoned by operation of law. But no assets that are not scheduled can be abandoned by operation of law.
Thank you. Mr. Gardiner, contract having nothing to, having not as its object the liquidation. Contract is entered into at a certain date, means executed by the parties. Then the company, with one of the contractors, is dissolved, and after that, the contract is closed. What's the effect of the dissolution in that situation on the validity of the contracts?
And in your hypothetical, it's closed within the 2-year period of reinstatement or not?
Within, but there's no reinstatement at
Okay,
any time.
okay. Well, my view my view is that consistent with section 1405, when a company is able to dispose of assets, well, first it says it can collect its assets and then dispose of them, and then it also indicates it can take care of or satisfy obligations. In my view, the closing of a transaction pursuant to an agreement that's already been entered into would be consistent with the dissolution and winding up procedures permitted by section 1405. So I believe they could close the transaction, and that closing would represent valid actions, because that would be moving the company towards liquidation, winding up in proper liquidation of its assets. It's entered into a contract. What does it do? It has to do something to get to the ultimate point of ceasing its operations and winding up. So I would say it could take those actions to close the transaction.
Thank you. Any follow-up question?
Yes, I want to be more specific on a follow-up. Assume the SPA, read the SPA. Have you read the SPA?
I have looked at the SPA. I did not read it carefully.
Okay, take my representation, and it's a undisputed point that it was signed between the parties, EuroGas and Belmont, before EuroGas was dissolved, okay? The closure date is after the company EuroGas was dissolved. The contract now, please listen to me carefully, because there's contract, as you mentioned, to dispose. This one is to purchase majority shareholding in a company that is abroad, that has an ongoing project. Is that considered, according to your opinion, again, I'm not leaving the court aside, avoidable only contract that falls within the scope, the spirit of a winding up?
I'd like to answer that question. I would like to, could someone tell me which tab section 1405 is? Is it 8? I just found it. It's tab 8. So my answer to your question is I think it could do that. In other words, it could still close that transaction, because subsection C of 1405(1) says a permitted action after dissolution is discharging or making provision for discharging liabilities. I view that to contemplate performing obligations under a contract. So even if the contract entered into prior dissolution involves the acquisition of an asset, still the company is bound by that contract, has a duty to perform, and the statute permits the discharge or making provision for discharging liabilities. And I view liabilities to include contractual obligations. As it moves forward towards liquidation and winding up, it has to take care of its obligations, and one of them is to close the transactions it's agreed to enter, as previously agreed to enter into.
But what about if it is a closure date has not arrived even?
That nothing changes in the analysis I just stated. The closure date is when it is. It has an obligation. I assume a contract had, which I didn't read carefully, but I assume it had conditions involved which needed to be satisfied in order for a closing to occur. When those conditions were satisfied, it would have been legally obligated to close the transaction, and I don't think it would be viewed as inconsistent with the statute to proceed to do that closing.
And it could issue checks
Issue,
after the company is dissolved.
when you say issue checks,
Issue checks, take his checkbook and for EuroGas one, I issue a check to Belmont.
if that's consistent with an obligation it has, particularly one that it entered into prior to being dissolved, then I would say yes.
And could issue new shares as well?
Again, issuing new shares, I also agree it could do that, in particular in the fact that the action was occurring within 2 years after the administrative dissolution, because within that 2-year period, again, if it were to reinstate, everything would have been permitted. Ultimately, if in this case it wasn't reinstated, so there might be a question as to whether at that point there's a problem with the shares, but I think at the point in time of closing prior to that 2-year period being ended, that it should be able to have issued those shares, and that's what I believe it did.
And what about if under the SPA, assume with me, I'm not saying that is the case, assume take another SPA with the same chronology. There is no obligation on the part of, no obligation, no consequence.
No obligation to close.
Yes.
So you've entered into you're proposing a hypothetical where there's an SPA entered into, but
And EuroGas one can take the position not to close.
can take the position not to close. In a strange hypothetical of a company entering into an SPA, which then it doesn't have an obligation to close, I guess in theory, you'd have to reconsider whether it could close in that particular case if it had been dissolved. However, even if it did, and it did reinstate within the 2-year period, that would be perfectly fine.
Yeah, but the assumption is that it has not been reinstated.
Okay.
What is the statute of limitations in all this?
You know, I'm not sure what the statute of limitations is in all this. I could look that up, but I don't know off the top of my head.
And whether or not one party is aggrieved or not, does it change any of your answers?
If one party's aggrieved or not,
You said it can discharge its obligations. Who is the aggrieved party in the context of a situation that you described when reading the statute as part of its obligation to discharge? Who's the aggrieved party?
well, an aggrieved party would be if a company, let's take your example, or this case, the SBA was entered into. EuroGas had an obligation to issue shares. The closing was to acquire the 57% and issue shares, right? That's the transaction. So if it didn't issue the shares, but acquired the 57%, then I guess it would be Belmont that's the aggrieved party.
And if the aggrieved party is not requesting at a point of time that EuroGas one discharge its obligations, when it learns that the company is dissolved.
Well, I don't.
Assumption, sorry, I apologize, I don't want to interrupt you, I just wanted you to focus. Assume Belmont learns that EuroGas one is dissolved. And from the moment it learns, it is not requesting EuroGas one to discharge its obligations. How could then EuroGas one perform under a contract, under the provision you read?
If EuroGas one has an obligation under the contract, absent like an agreement to modify the contract, but it has an obligation to close, then I think the statute would still permit it to close. Because in the facts you present to me, Belmont might say for a time, oh, we don't want you to close, but it could change its mind. Or Belmont could go bankrupt and some trustee or some other party could take control and say, why didn't you, could pursue remedies. So I think it would still, under the statute, not be, somehow, the fact that Belmont isn't demanding performance, I don't think that would impact EuroGas One's ability or permission under the statute to close the transaction, because it still has a liability to the contract. It doesn't matter to me whether or not Belmont is asking for them to perform or not.
Can I add to that too? I think what you're asking, part of what you're asking is, if a contract is voidable, then the other party has the right to void it. And I think what you're saying is, could Belmont have, refused to close or accept a consideration? I think it is possible that this contract is voidable, but then Belmont could not have accepted the consideration and disposed of it. That would, because at that point the contract is no longer viable.
I understand, but stay with me on that scenario. Imagine Belmont learns 5 years after that contract, SPA, at the time of closure, EuroGas One was dissolved, okay? And it says, take the position that, the assumption that full performance, the obligations in full had not been discharged by EuroGas One. It's an assumption, had not, in full. Could Belmont take the position, I learned today that at closure date, your company was dissolved, and I don't want to exercise my right to obtain performance. Then how could that, then you have no obligation to discharge any liabilities. How could you, EuroGas One, then exercise that voidable possibility?
Well, I find the hypothetical a little bit difficult to follow. You're talking 5 years later?
Yes. In my view, I don't think it changes anything unless EuroGas and Belmont have agreed to, you say 5 years later. No, it's still a contract that was entered into before the dissolution occurred. But obligations were not discharged.
Obligations were not discharged. Then there's a question after 2 years whether or not some of those obligations, depends on what those obligations are. There's a question maybe whether some of those obligations could be discharged. But there's also a possibility that could be. I don't think it's clear.
Okay.
No further question? No. Thank you very much.
Thank
both
you.
of you. And thank you very much. That's now in the transcript. Where are we now?
So Mr. Anderson is the next witness and he's ready.
Okay. We started 1 hour ago, so we proceed. Good afternoon, Mr. Anderson. We have been called here to testify as an expert witness. Can you read the statement in front of you aloud, please?
Yes, Mr. Chair. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Thank you. Any direct?
Then, Mr. Chairman.
Mr. Garabi?
Yes, thank you, Mr. President. Dear colleague, Mr. Anderson, good afternoon.
Afternoon.
I will start with you. First first testimony and the CV. Well, prior to your CV, I apologize, if you're on the paragraph 2, you cite Chambers Global's guide rankings. Is that something important in Canada that people rely on? Because here it depends on the event and who thinks it is important or not. So that's why you listed it, and I'm asking you, is that something
It's,
important?
it depends what you mean by important, but yes, it's something, it's a lawyer rating service that is becoming more important in Canada because they've put out a specific Canada guide since the time of this expert report. And our belief is that clients look to this expert guide when they need an expert in order to assess who are the best people to hire.
For clients, I could understand, but what about if you go to before a judge, for example? Canadian judge, they ask you to be an expert opinion. Would you put that credential forward? I'm listed in the Canada section.
Yes.
You would. And what are, here, I think, for example, arbitration, you have, I think, superstars, band 1, and you have all members of the tribunal. Then you have band 1, band 2, band 3, where you have people like me and band 4 and stuff like that. Where are you in that?
In the chambers, I can't recall, to tell you the
Well,
truth.
I think I looked, you're in band 4. Sorry. Do you recall?
I don't recall. My marketing department handles where we are in these rankings, and I know new ones just came out in the last month or so, and I didn't look.
You mean you may have been better ranked before?
I have no idea.
All right, then moving on to publications. First, I see you're a transactional lawyer, correct?
That's correct.
Right. You're not a litigator, are you?
No, I've never appeared in court, and this is my first time as a witness, so when you say, do you normally put these accolades after your name? I said yes, I'm guessing, because I've never done this before.
And I see also that you have a number of publications, but they're transactional related publications. Have you ever, for example, you cite a number of them. The question I have is, have you ever written on contractual law questions of interpretation? Have you written a book or an article on the subject?
No, I've not written a book or an article on the subject of contractual interpretation.
And I assume you never acted as an arbitrator or as a judge.
I've never acted as an arbitrator or a judge.
Okay.
And I've got a lot of sympathy for them,
Okay.
having had to try to figure out what's been going on here.
Well, I have also sympathy for you because you take the little bit the shoe of a judge, basically, in your opinion. Your two opinions would say a judge would have construed this situation as follows.
Correct.
Isn't that what you do?
Correct.
So you're kind of a novel. It's your, how do you say, visitage. No. Anyways, you offered that to us. So what I would like to do, dear colleague, is to engage with you in 3 ways. First, to see whether you identified the right principles to carry out what your mission is. 2, whether you applied these principles. And 3, whether you have applied these principles correctly. Okay? So I will start whether or not you have identified the required principles. All right? And I will sorry, I have to do this. It should be at paragraph 10 of your first statement. You mentioned governing legal principles, and you say under British Columbia law, the interpretation of a contract is an objective exercise. Courts applying British Columbia will, and you start with A, initially interpret a contract by giving the words of a contract their ordinary meaning. Okay.
Correct.
Then I would like to pause there for a second and then go to paragraph 16. And I read paragraph 16 in conjunction with 10A, because at 10A you identify a principle, and then you identify other principles that allow you to step away a little bit from A.
Correct.
And my understanding is that you say, well, if I interpret the contract by giving the words of the contract their ordinary meaning, it would lead to this result. Yet, for the reasons and based on the principles, I'm not here to discuss yet the fact details, but based on these principles, I think it would not be sound to give the words their ordinary meaning.
Yes, I say,
Okay.
summarizing, that it would lead to a commercial absurdity,
I
correct?
understand. So, and let's go through the three reasons you state. You say the purchase price could at all be sold for less than a specified threshold of 3 million, and then the condition would never be capable of being satisfied. Then you say in particular, the purchase price shares, since they were all sold for less than the specified 3 million, could not thereafter generate in additional proceeds for Belmont to achieve the 3 million threshold, right?
Correct.
And then you say the share purchase agreement contains no positive obligation on the part of Belmont to use reasonable efforts to sell the purchase shares with dispatch, or at all, with the potential illogic result that the 57% would never be transferred, despite EuroGas having delivered the purchase price shares and otherwise having fully qualified with its obligations under the share purchase agreement. And then, in each of the above circumstances, EuroGas would have based the NRAR, the purchase price shares, and given the covenants regarding other royalties and registration rights, all as a consideration under the share purchase agreement, and would receive nothing in exchange. And here I put to you, aren't there principles that allow a court to correct or remedy any of the alleged pathologies you have described, other than by deviating from the ordinary meaning of the contract terms? And allow me to elaborate. For example, if somebody has paid not the full amount and the other parties, such as Belmont, has kept the shares at the old amount, isn't it principle on just enrichment? On B, isn't there a principle of good faith that the judge could exercise in applying whether or not a party performed those terms?
Well, I think,
Or abuse of law?
so I think unjust enrichment is
Yeah.
actually a remedy that people seek when they're wrong, whereas when we're trying to interpret the contract to determine whether people are wronged or not in the first place, we need to understand what the contract requires people to do. I don't see unjust enrichment as being a statutory interpretation principle or a contractual interpretation principle. I think the other comment that you made, that courts will impose in certain circumstances an obligation on parties to undertake their obligations in a reasonable fashion. Yes, I've certainly heard of that, and it's often imposed that where the parties where one party is required to provide a consent, for example, the courts will imply an obligation that that consent is not to be unreasonably withheld. So yes, there is, in interpreting a contract, the imposition of a reasonableness standard, to answer the second part of your question.
But because, what I understand is that what you say here is that the contract terms could be clear, but if it would generate this result, and this result would not be fair, basically, and that's why you go around it. You don't say, well, it's unclear, let me go and do an interpretation. You come and say, this is clear, but it would lead to this, which I don't think is correct, because then the one party could not sell the shares, or would sell them at a lower price, and the other one then could not, then the beneficiary, the Belmont, could keep the shares in the amount, and that would be unfair. Hence I say there are remedies available if some party in applying the contract terms abuses of it, or that application leads to an injustice.
So just to be clear, you said two things. First, there is no abuse if you look at the specific words that were here. What I'm pointing out is that if you look at these specific words, they could lead to a commercial absurdity. You could have, in effect, this is, one could argue, a gambling contract. Will you be able to sell these shares for $3 million? If yes, I get something. If no, I lose. That's not a commercial transaction, right? That's a commercial absurdity. And so the principles of contractual interpretation require a court to depart from the plain meaning of the words where it would lead to a commercial
Could we
absurdity.
take it step by step? A, B, C, for example, the B. What would be the commercial absurdity of B? The share purchase agreement contains no positive obligation on the part of Belmont to use reasonable efforts to sell. So isn't that implied? Or if it's not implied within the good faith requirement by the court, assure fair application of the strict terms of the contract?
Well, there is no strict terms of the contract requiring any sale. Indeed, the contract in other places contemplates there will be no sale.
Okay, but a certain amount needs to be achieved, correct?
But the contract suggests that there need be no sale whatsoever, and the investor could retain the share ownership because they think it's a wonderful thing to retain.
The investor, who do you call it, the investor?
This would be the vendor, Belmont, who is now the investor in EuroGas, and the investor in the TALC project to the tune of the 12 million shares that represented approximately 10%.
But that would be an abuse of law if you would do that, wouldn't it? If the other party can put up the consideration, and this Belmont, by way of playing with the shares, would end up benefiting from the shares and the amount that it has partially received. Or if EuroGas wishes restitution, could argue unjust enrichment, for example, and Belmont will restitute. So that's why I am puzzled.
So, as I say, unjust enrichment is a remedy. When we're trying to figure out what the contract means in the first place, we don't come up with constructions that necessitate the reliance on an unjust enrichment remedy to correct the deficiency.
But I thought that your plain interpretation of the contract led to a clear result from which then you derogate because you think that it is absurd.
Yes, that's exactly what I said.
Yes,
because it
that
leads
is-
to a commercial absurdity, not because it's unfair or something else, because
Okay.
it leads to a commercial absurdity.
But what I'm saying that there is no commercial absurdity if there are remedies under the law that could correct the pathologies, that the absurdity are not
No.
absurdities.
No, as I've told you, that's not
Okay.
the approach that's
That's your
taken.
approach. Well, we differ on that approach. Because then the principles of unjust enrichment, abuse of law, good faith, would not.
Mr. Chairman, I think the witness has answered this question repeatedly. Is there a question, a new question that he needs
Sir,
to
I was
ask? on this
going
issue?
on, I said I deferred,
Right, but
what, but,
I'm looking for questions to the witness rather than
well, it's part of the
argument of
debate.
speeches from counsel.
It's a back and forth.
I think Mr. Moy is right
Okay.
in principle.
I'll move on, I was moving on.
Although, of course, it's difficult sometimes to have a reaction to an answer one doesn't like, but
There's paragraph 10, I'll go back to the paragraph 10.
Yes,
Then let's see the principles you apply. You first one was the words of a contract, their ordinary meaning, okay? Then you go on, say, have reference to the contract as a whole in interpreting the words of a contract. Individual words and phrases must be read in the context of the entire document, okay? Then you go examine the factual circumstances that give rise to the contract to assist in interpreting the contract. Ambiguity is not a prerequisite to considering the surrounding circumstances, but the circumstances must not overwhelm the meaning of the contract. And D, give commercial efficacy to the parties' agreement in business settings. Interpretation which are commercially absurd should be avoided, but the purposes of the interpretation is not to rewrite the contract nor relieve a party from the consequence of an improvident contract. On D, I understand the latter part of the sentence, but the purpose of the interpretation is not to rewrite the contract nor relieve a party from the consequence of an improvident contract. This is precisely what we were discussing. Basically, you're saying, yes, you should engage in interpretation as long as it is not commercially absurd, that you cannot use the commercial absurdity opt-out because the purpose of the interpretation is not to rewrite the contract nor relieve a party from the consequence of the improvident contract. Correct?
correct,
Okay. So at least on that we agree.
yes.
Now, there are footnotes, references to the cases. Have you read these cases?
Yes,
Okay. There is no footnote when you say interpretation which is commercially absurd. I don't find any support for that.
so that's footnoted to Scanlon, is that right?
Is the gentleman a colleague that wrote the report with you?
He's an associate assistant witness with documents. We can pull him away.
Even if he was, I had no objection, I was trying to find out.
No,
I'm sensitive.
I don't know who this person
Okay,
is.
but even if
I
it
met
was,
him, but I can't.
even if it was your sister, partner, brother, he would be welcome, as far as I'm concerned.
Thank you. So I see that we here cite page 744 at 770.
When you say here, you cite what? What are you citing? Can we start with the case?
Well, I'm looking at Scanlon versus Castle Point.
But here you're saying commercial efficacy to the parties' agreement in business settings. I was talking about the commercial absurdity.
Okay, so that's Jedfro, is that footnote 12?
I found your reference to the absurdity only in your second report. And that was consolidated Bathurst versus mutual boiler. Is that correct? I found that at page 7 of your second report. If you go to D, you cite unrealistic result or commercial absurdity.
Sorry, which paragraph did you say?
I have a page number 7, and it's at D.
Paragraph D, yes.
And here you say unrealistic result in commercial absurdity. This is the first backup that I found, but it's in your second report. And I understand you refer to consolidated Bathurst versus mutual boiler. Is that the reference you provide?
Yes, that's the reference that's provided on page 7.
Okay,
Correct.
no, but I understand that it's for point 7, but it's a case law that you rely on to say that you get out of the strict interpretation of the contract, plain meaning, when it's absurd, correct?
Well, I wouldn't say get out of, I'd
No.
say it's one of the rules that's
Yes,
applied, yes,
yes.
that's correct.
Okay, have you read that case?
Consolidated bachelor's?
Yes. Does it contain, and does it concern the sale of purchase agreement?
No. This is a case from our Supreme Court of Canada that involved the purchase of a contract of insurance and was related to claims under that contract of insurance and what was being purchased and what was not being purchased.
Okay, so you call
But this case is the sort of thing that you learn about in law school. In fact, I was taught it in 1989, and it's one of the leading authorities in our country on contractual interpretation and is cited in hundreds, if not thousands, of other cases and followed. It is the highest authority in our country since the appeal to the House of Lords was
I'm not
done away
challenging
with.
that, but sometimes, you know, when I read cases when I was at law school, and I realize now that I knew them better when I was at law school. Can we read that together?
Certainly.
It's RL0084. You qualify a insurance contract as a purchase contract? Well, I was curious to see the qualification of that. A purchase contract? Is it a purchase contract or is it an insurance contract?
Well, let's go see it.
Okay. Are you waiting for my question?
Yeah.
Oh, I'm sorry, I thought.
Where are we going? You said you wanted to leave me somewhere, so I'm looking.
I'm sorry. But just by courtesy, I was waiting for you to, maybe you had something to say. I understand to be an insurance contract, correct?
Yes.
Okay. And I see that there's a difference as to what is covered or not under the insurance. Okay?
Correct.
And it says at page 2, middle of the first paragraph, the insurer, as it was right, sought in the terms of the contract to limit its exposure to accidental loss, and did so by seeking to confine the definition of accident. And then the insurer was relying on corrosion, saying the word corrosion by essence excludes accidental loss. And then the court said such an interpretation would necessarily result in a substantial notification of coverage under the contract, because then it would then defeat the interest of the person who was covered, because it means that he would not get coverage, basically. That's why I don't understand even the relevance of this. Basically, they're interpreting what is covered under insurance or not.
They're interpreting a contract of insurance.
I understand.
Correct.
I understand. But yeah, you can always say, make an analogy with any case, but would you agree with me that the analogy is quite weak?
No, as I say, this is a leading authority in Canada, not for insurance cases only.
Yes.
And it's something that you can find referred to in hundreds, if not thousands of cases, as I said. So this is,
So there is no misunderstanding. I value very much the Supreme Court. I value very much that everybody relies on this. But is it a reference to point out that an absurd result really would allow you in the same way you're doing to leave the ordinary meaning? Because if you move on, maybe I can move on and say, look, are they really looking at the question of absurdity? They are looking for the true intent of the parties, if you look. I mean,
Yes, no, that's what the quote says, absolutely.
Okay, so it's more the
Advanced
true intent.
intent of the parties at the time of entry into the contract,
Yes.
consequently, literal meaning should not
Yeah.
be applied. Correct?
Okay. I'll come back to this, just for the sake of time, I'll move on a little and then go to end of D.
And
Footnote
D,
12.
are we in report 1 or 2?
One, I apologize, one.
Report 1,
One.
end of,
Two, paragraph, footnote 12.
footnote 12, yes.
So again, we're in your paragraph 10, when you say, okay, first of all, you look at the meaning, clear meaning, then you say you have recourse to something else, you list commercial absurdity, for example, tests, you cited the case we just read, and then as to the limit of the recourse to the commercial absurdity and to the business settings, you say, but watch out. You can look at commercial absurdity, business efficiency, but the purpose of this exercise is not to rewrite the contract nor relieve a party from the consequence of an improvident contract. And you cite Jethro, which you should have at RL0088, which
Yes.
is the second and last case. And page 3 of that decision,
Page 3 of that decision, yes.
it says, I read, as a result, the applicants should not receive the return of their initial investment in the joint venture as the monies were formally forfeited by the foreclosure on the note in the trustee. Then it says, the doctrine of unjust enrichment also did not apply. The applicants choose not to pay and suffer the consequence the law prescribed. So the feeling I have, I come back to the answer the president said I didn't like, is you know, you go into the ordinary meeting, you can opt out of it by using other principles in certain circumstances. One is commercial absurdity, and we saw the case you rely on. Then you say even commercial absurdity should not be used to restore the bargain. And when you look at the case that is cited, it's what we were discussing, wasn't it? That there are even remedies under, such as unjust enrichment, that could address your, any concerns you identified at paragraph 16.
I thought in this particular case, they said those weren't available, but that's not, this is not a case that I've cited as being on all fours with our situation. This is again a case where we're drawing from it general principles of contractual interpretation. And so,
But I'll move on to another related topic, but the feeling I have when I read the case law you cite, that those terms you want to, clear terms that you want to deviate from, you want to deviate from certain of these clear terms based on pathologies, and the cases you cite show that there are remedies under the law to allow these pathologies to be addressed, and they cannot serve as an excuse for you to undo the clear meaning of a contract.
No, I'm not aware of any case that says ignore the rule of contractual construction because it's possible that there's a remedy in some other manner. We're still trying to determine what the contract requires in the first place before we even get to the question of, is there a remedy based on what we now understand this to mean? So I'm still on the principle of what does this really mean, what was the intent?
Okay. I then want to a little bit engage further with you on the different principles you set out. Don't you think you have left other principles out?
Yeah, there's lots of principles that I
Yeah.
didn't think were applicable, contra proferentum probably being a key one.
Okay, but can we start with the question, what is the intent? What was the intent of the parties?
Certainly.
Why don't you put that? I mean, every case now, especially the Supreme Court that you've been identifying, lists that as the primary thing somebody looks at, the intention of the parties. And I see here that you engage in an interpretation, deviate moreover from the clear terms of the contract, and you don't even have intention of the parties nowhere listed.
Well, in Canada, in British Columbia, intention of the parties is to be determined from the four corners of the document. We've got a rule against parole evidence and the like, so that you're not supposed to go and say, gee, what I intended was a result of X. We're supposed to look at the contract and determine from the contract what a reasonable person would determine to be the intent of the parties and what they were trying to achieve. We then have the principle that allows us to go beyond and examine factual circumstances where that's of assistance to determine the intent of the parties.
And
So, and we've done that.
I understand that the judge would not take for granted what one party says about its intention. But am I correct or not that the judge will ask the parties what was their intention?
No.
It would not.
Typically not. As I understand the law, the determination of intention of the parties is an objective exercise, not a subjective exercise, and hence we don't call you as a witness to tell us what did you think you were doing here, what did you want to achieve. The approach is to determine what a party reading this would expect you to have wanted. Otherwise, well, I don't want to speculate as to why we have that rule, but I'm sure there are reasons for it.
Let me move a little bit forward. What about the position of the parties at the date of the dispute? Don't tell me that the judge is not interested in that.
The position
Of the parties, on the intention of the parties. The position of the party, there's a dispute. And the parties to the contract said, I meant that, and now I think it means this, and I want this. Isn't that relevant?
I think the Genfro case that you sent us to look at is an example where that's exactly not relevant. So didn't that case involve the joint venture that one of the partners wasn't contributing and said, gee, I want this to be at an end and we don't want this
Stop
joint
there.
venture to
No,
exist?
Mr. Chairman, he should be allowed to
No,
answer his question.
I apologize. It was not to interrupt you. You can finish, but I was
No,
interested in one
I
sentence.
think he needs to finish now before another question or comment is made.
Please do. I apologize. It was not to stop you from talking. Please do.
And so in that case, the position of the parties was that we don't want this contract to be afoot. We would like it to have been dealt with in the past. And the court said, no, you didn't do that. This contract is still in effect and you didn't terminate it or waive it or vary it. And we've interpreted it to say one thing and that's what it says. So coming to the court later and saying, I wish my situation was different or I would like my situation to be X, that is not relevant in assessing what this contract meant on the day it was signed.
I understand, but in that case, there was a motion to oppose, correct? That's why there was a dispute.
Yes.
Okay, so that's my point. Maybe I should have gotten there sooner. And maybe before we discuss that, who has standing in Canada? For example, if there was EuroGas and Belmont, and in a dispute, and if they agreed on the interpretation of the contract, and then a Slovak Republic comes in, gets some sort of standing, what would be the burden of proof? Who would have the burden of proof to say the position of the parties is not as they stated, but as the Slovak Republic or the third party says? Could it do that? What is the burden of proof? Who has the burden of proof, and what is the threshold?
You know, I think we're getting into an area that's outside my expertise. As I told you, I'm not the sort of person that litigates contracts at the end of the day. I'm the sort of person that puts contracts into place. And so my specialty is writing these contracts and understanding what they mean on day one. And so, honestly, I can't tell you who 5 years later has standing to bring a case in British Columbia to assess a contract.
Let's say you write a contract, negotiate a contract for your client with another party, two of you agree. And then a first party that claims to be impacted challenges the effect you want to give now to the contract, say that its meaning is different than the two parties to the dispute. Do you know who would have the burden of proof, and what is the threshold that would be applicable in those circumstances?
As I said, no, I certainly can think of examples that I've heard of.
Okay.
For example, our Canada Revenue Agency will often say that we think the outcome of this particular transaction is X and you need to pay some tax. And the parties can say, no, we think it's Y and we don't have to pay tax. And there will be a court case about that. But I don't know who bears the burden of proof and what sort of standing CRA has to bring that case. I just know it happens. But that's, as I say, not my area of expertise.
I'm embarrassed to suggest to you, because I'm not qualified, that's what my understanding is simply, so I don't want to misrepresent. My understanding is that the burden of proof would be on the third party, and that burden of proof would need to meet the threshold of fraud or collusion, which is huge, assuming statute of limitations on that. Would that?
You know, as I say, I'm no expert.
Okay.
And you said you aren't either, but I can't believe it needs to be fraud, because I know as a fact that our CRA reassesses and attacks many commercial transactions on the basis that we think this had a particular result that leads in tax payable, and they're not out alleging fraud. Fraud is something that's really, as you say, up there, hard to prove, and has consequences if you allege fraud and don't prove it.
Tax administration is a creature of its own. In all countries, I think, thank God, they can requalify the parties. I'll move on to the other standards. Don't you think a judge would consider who drafted the contract?
Yes, that's the contra profferentum
You
rule,
mentioned,
correct?
and whether one party is a professional or both of them are businessmen, would they consider that a little bit?
Certainly, they assess, that's part of the factual circumstances. Are these sophisticated business people or are they not? Yes, absolutely.
Have you considered that?
The contra profferentum rule, I have not been able to apply to this because I don't have all the facts. There's, you know, this is where I said I had a lot of sympathy for our panel, because when I was given the task of trying to assess what this is and what it means, I found myself missing many facts, one of which is, where did this contract come from? I've got a press release on February 14th saying, by Belmont, saying we've got a deal. And I've got a press release April 27th saying I've received signed agreements. And I presume the signed agreements they're talking about is the March 27th SPA. But I haven't seen any evidence as to who drafted it, where it came from, whether it was a lawyer, whether it was business people, and you know, I wasn't here for the testimony of the other witnesses, but hopefully they could tell us who drafted this,
Well, that's what
where it
my
came
point.
from.
That's what my point is that who has the burden of proof? question of burden of proof is not addressed. Contract referendum is not listed as a principle. I see the position of the parties and the specificities of the case, that there is a third party involved, is not assessed in the principles. And then whether or not the signatories are businessmen or not identified. Then may I suggest that you didn't set out also whether the correspondences and the amendments are relevant? Wouldn't the correspondences and the amendments to the SPA be relevant?
Well, I'm not sure what correspondences and amendments you're referring to.
I don't want to interrupt you. I'm not saying whether you applied it or not. I'm identifying the principles that you state. Then we will go whether or not you apply these principles.
So
But the
absolutely, if the
principles
contract
are-
is amended, then the contract is amended. There are many, many principles, and that's why it takes 3 years to get through law school, to understand all these principles. And when I'm asked a precise, narrow question as to what this contract means, I pull out the relevant provisions that I think are relevant, in my opinion, and lay them out and give you the resulting conclusion.
Okay.
So yes, I'm sure that we could spend a lot of time finding in a contractual interpretation textbooks many, many, many principles that aren't here.
I move on, for the sake of time, to whether or not the principles were applied. Okay?
Microphone.
I kindly ask you to turn to tab 76.
Tab 76. Is that in this little thing?
No, it's in the bundle one. Should be.
It's your opening amendment.
Yes, opening bundle one. It's R0106.
There's no 76 here. This goes from 1 to 20.
But it should be this one.
This one?
You can leave that aside, I don't think I would need it.
76. Yes, is this the R0106 bankruptcy filing docket?
Yes.
Is that correct?
Yes. In your first report, did you take into consideration what is said here by the representatives of EuroGas, namely that, well, you can read it, that they own 1.6 million and they think it would be lost if no payment is made.
Which page or,
It should be the tab pages, 04, 28, 07.
I've got a page 68, 69, 70, 71.
71, it should be 71.
Thank you, thank you. Now, you're buying this Rosamond talc deposit from Belmont, correct? And you did that by issuing 12 million shares. No, there was subsequently going to need to be issued 12 million shares, but they haven't been issued. They would prefer cash at this point. No, I've not seen this before, so I've not taken this into account. When was
Can you
it?
proceed a little bit and read again? Take your time, and now you're own 12 million, if they're willing to take it, they want 1.6 million Canadian dollars, is correct? You have the ability to pay that 1.6 right now, no? Is it true that your testimony was that it had 4 to 6 weeks to pay that, or the deposit would be lost? There will be distinct possibility. I mean, that's what I was talking about, the intention of the parties, and
When was this?
in 2004, before the bankruptcy.
2004, so it's 3 years after the contract.
Yes, so you have the person, the buyer, declaring before bankruptcy proceedings that if it doesn't pay a certain amount, those shares will be lost. That's why I was asking you whether you considered the party's position, the party's intention, and then all the correspondences.
Well, as I say, I have not looked at this. I question its relevance, given it was 3 years later, and this contract of 2001 may well have been amended by that time. And lastly, to tell you the truth, I don't even know what this means. We could lose it. If I don't pay my mortgage, my bank will take the house that I own. But so I don't see that this is of relevance in terms of trying to assess what the legal position of the parties was at the time of the 2001 contract.
Mr. Anderson, you're moving ahead, and I don't want to interrupt you, not because my learned colleague, Mr. Enway, may object, but just by courtesy towards you, because you're your colleague. But I was there, question one was whether or not there was, you identified all the principles, that two, whether you applied them, and three, whether you applied them correctly, and there when you get to the relevance. But I'm at stage two.
Stage 2.
Okay? And my understanding is that when you issued your report, you did not consult that. I'll move on to another topic.
Correct. My report identifies what I consulted and what,
Yes.
and does not identify what I did not, because I didn't know whether it existed or not.
Okay. In tab 66, which should be C0343, January 18, 2005. Tab 66, C0343.
Correct. I have that.
May I suggest that you didn't take that into consideration?
Yes, I did.
Not in your first report, I'm talking about your first report.
I'll have to check, but I certainly saw this and read this, yes. And this was certainly part of the voluminous statements made by the parties, some of which were more or less clear.
My question was just simply for the first report, and my understanding is that it was not considered in your first report. What about tab 67, August 25, 2008?
Yes.
C0344.
Once again, I do want to separate between report 1 and report 2. I think of them all together as my opinion, but certainly I've seen this and considered it, perhaps in the second, perhaps in the first, but certainly within the totality.
Okay, but certainly not in your first report when you reached a conclusion, correct?
Both reports reach the same conclusion.
I
yes.
understand, but it's, hard when I suggest to you, when you write a expert opinion for a party, and then to change that, isn't it? It's a little bit more difficult.
No, I'd be
Would you
happy to
find-
change it. When I was originally, if you gave me facts,
Okay,
like I'd love to get more facts.
Okay.
The financial statements of Belmont say that it received the repricing of a warrant valued at somewhere between $100,000 and $200,000 as consideration for this transaction. I see that referred to nowhere in the SPA. And I see it referred to only in these financial statements. Clearly, I don't have all the facts.
Yes.
Once I have all the facts and it leads me to a different conclusion, absolutely, I will provide a different
okay.
conclusion.
Well, let's pause here, whether you would provide a different conclusion. You say you are not an expert, could not answer the question of burden of proof, and the fact that there was first-party evidence, so I leave that aside. But based on the two documents that I just read, the three of them, one of them you said you didn't, whether it was in your first or your second report, which is the bankruptcy.
Correct, the bankruptcy I did never saw.
The two others that you saw in your second report.
Yes.
Can I show you now two other statements? One is page 180, it's day 2 of these proceedings.
Do I have that?
Yes, you should have in the pochette.
Ah.
And, this is Mr. Robal on the stand, and he was asked, page 180, do you think today you, Belmont, EuroGas 1, EuroGas 2, EuroGas 5, EuroGas 6, anyone that you're aware of has any claim to ownership of the 50% shares of my client? Belmont, and the answer is honestly no. Then follow-up question, how about the money you paid? Basically, you know, it's one of your hypotheses where you conclude that there could be an injustice, and you use that to part from the clear meaning of the terms. The answer is, that will be a situation which the lawyers will have to sort out. I myself am not the guy who initiates lawsuits. On the other hand, it is very difficult to initiate a lawsuit because Belmont could argue that we were in default of the payments, etc. So they would come with a damage lawsuit. It's a very difficult question right now. And before you answer, if you kindly, a question that I'll put to you, if you look also at what is said during the testimony from Mr. Agiagos, he was asked, can you offer any explication as to what that meant? The company holds the allotment shares pending a settlement of the amount guarantees. Then he explains, says it never happened, nothing ever happened. Then when you issued on the right-hand column, 1156, page 95, when you issued those, did anyone at the stock venture exchange, when you issued those, is in reference to the letter I mentioned, I read to you previously, which was one of the 3 exhibits I asked you to consider. It is attached 66, 67, remember?
Yes, the two press
Yes.
releases saying we think we own this or we own this, and we're
Yes.
challenging
Yes.
the expropriation, yes.
And then he says, when you issued those, in reference those to tab 66 and the following one, namely tab 67, did anyone at the stock venture exchange, EuroGas 1, EuroGas 2, Mr. Robo, anyone in the world challenge the fact that this was inconsistent with your financial statements? No. Then question, today is anyone apart from the Slovak Republic alleging that you do not own full ownership of the 50% shares? Answer, Slovak Republic is, question, except the Slovak Republic. I'm asking you, does anyone in the world? The answer is no. So does all these things change your conclusion? You have EuroGas 1, during the bankruptcy proceeding saying, well, I have to pay, it's going to be lost. Then there is evidence it was not paid. Then you have, during that process, Belmont sending a press release to the world. It's not a private transaction between 2 parties, saying, I own these shares. And then in these proceedings, both of them, now one is EuroGas 2, but the signatory of the SPA is Mr. Rosa. Both of them are saying there is no claim. So does that change your conclusion?
No, not at all. This is a statement that was made, this one was made 15 years after the fact. The one in 05 and 08 were made 5 to 8 years after the fact. The question I've been asked, and my conclusion, is based on what was the state of affairs in 2001, 2002, when this contract was entered into and performed. The statements made 10 years later, who knows what they're made on the basis of and why. I could certainly understand, for example, someone saying, gee, if this is owned by EuroGas 1, it's owned by EuroGas 1 creditors, or some such thing, and it's better to be owned by Belmont. So I'm not saying anybody's lying, but I could certainly see that people would allow the changes in the factual matrix over the last 15 years to color their perceptions.
Yeah, I understand that's what you're suggesting, but I have 2 things to say in response to your suggestion. Is that to some extent we could entertain that suggestion if I had not shown you other documents, namely EuroGas 1, within the bankruptcy proceedings, also taking that position openly before the trustee that initiated bankruptcy proceedings, which has access to documents to follow up.
Yeah,
And it says
those statements were 3 years after the fact. As I say, we look to contemporaneous statements. We look to, immediately subsequent statements to try to ascertain the position of the parties. We don't tell people wait 10 years to bring this lawsuit and we'll see what you say over the course of the next 10 years. We assess what the facts were and what the contract provided for in the context of that factual matrix.
But then I come back, if you would do that, that there must be a threshold, frankly. I'm not talking here about a third party. I'm talking about the judge with the two parties trying to re-qualify. The threshold must be very high. I mean, you have both parties now, a few years before a bankruptcy court, taking this position that the transaction was not complete. Do you agree with me that at least you should apply a different threshold?
You know, I'm sure that you and Mr. Anway and the panel understands a threshold that should be applied in this hearing. I honestly do not. All I was asked was, based on all these facts you have, tell us what you think the conclusion is. And that's what I've done. And whether that's sufficient for this panel or meets a particular burden of proof, I don't know.
Now that you have all these elements, don't you think that at least it attenuates what you have said in your report? Because you know that you have both parties that take this position,
No, as I say, it's a matter of weight.
Okay.
And if you showed me things from 2001, 2002, 2003, I'd be much more interested and say, you know what, maybe I need to reconsider. But when you show me things from 2005, 2008, I'm not particularly interested, and a BC judge wouldn't be particularly interested. That's what I'm trying to assess. What would the BC judge applying BC law, what conclusion would that person reach?
But even if you add the one in 2002, 2003, don't you remember that those financial statements had provisions that Belmont was keeping the shares as a guarantee, and other correspondence showing that the transaction had not been completed. You used the words to be completed. We have to do this to complete the transaction. So even if you take that into consideration, the whole thing, don't you think you're doing something wrong?
No, not at all. I think when you read my report, I think it's crystal clear that there are post-closing obligations that were secured by the retention, the security arrangement of retaining the 57% shares in a trust or escrow, and that was to secure not an obligation to actually receive 3 million cash, but to receive the 4.1B and 4.1C shares. It may be that in 2003, 2004, parties reached different agreements. I'll agree with you that say, gee, maybe you'll keep those 3.2 million shares and we'll give you half of the 1.6 million. Yes, I agree, the contract may have been amended, but my question is, where were we in 2009? The question I've been asked is, what was the position of the parties at the time of this contract?
I understand that, sir, but the other problem that I have combined with this, the problem that I set out at the beginning, is that you're saying that the terms of the contract are very clear. And if the terms of the contract are very clear, they actually lead to the statements that I just read from the parties and the one of EuroGas for the bankruptcy court. So that's the second problem I have, is that you want to get out of the terms of the contract based on the principles of absurdity and others that you're applying. So it's just not one problem, it's the way also you want to get out of these.
Is there am I allowed to see a monitor? Because that was a lengthy question that had a few parts.
I also don't think there was a question.
I can repeat
But
that.
I had a number of comments in there, in fact, so many that I've already lost track of them.
Okay,
So I guess the thing that really jumps out at me is you just made a statement that, for example, a businessman's suggestion that he may lose shares in 2004 in bankruptcy proceedings is consistent only with one conclusion, where it could be a whole variety of things that causes a business person to say, maybe I will have these shares, maybe I won't.
No, that's not what I'm
There's,
trying.
so, you know, I keep and in addition, I'm certainly aware of amendments that were made to the transaction after 2001. That other people can comment whether those were validly made or not, whether the company even existed when it was entered into them. I'll leave that for other people, that's not my expertise. I'm just focused on what happened in 2001, what was the position of the parties.
I understand.
And I'm not trying to avoid anything, I'm trying to interpret what was actually intended here.
I'm not saying, sir, you're trying to avoid. Let me put it a different way. My understanding is that you considered the terms of the contract in 2001, I'm back with you in 2001, clear. But you say based on certain principles, which I have questions as to whether or not these principles are complete, but leave that aside. Based on these principles, if I were to interpret the clear terms of the contract this way, it would cause these problems. Therefore, I reach another conclusion. And I read to you that those who are parties to the agreement don't see any problems with the pathologies you identified to search for another interpretation. So unless you identify a public policy problem in the terms the way are construed, I just cannot understand even your philosophy, your approach. Can you?
So I guess first, the statement you've made is that I'm looking, once again I don't have a monitor, but I'm looking at the clear words of the contract. No, what we're talking about here is just the words of section 6. I'm also applying the rule whereby I interpret the contract as a whole. And I'm certainly alive to and giving absolute effect to 4.1b and 4.1c, which are the mechanisms that are referred to throughout the materials that have been described to the shareholders in approving this transaction, that entitle Belmont to receive additional shares, not a particular amount of money, but a particular amount of shares. And I'm interpreting all of that together so that it hangs together and gives us a rational result, as opposed to treating section 6 on its own and as if it raises a separate right on the part of Belmont in terms of what it's entitled to receive under the contract. I think, I don't know who drafted this contract, I've told you that before, I can't apply the contra proferentum rule, but I think whoever drafted this, to be blunt, did a very sloppy job. And the best thing I could do is to try to tie 6 to 4, to make it all hang together.
Okay, a sloppy job for whom? I'm 100% convinced that if one of the parties had recourse to your services, it would be excellent. But a sloppy job for whom? Can you say who is the aggrieved party here? Based on the plain meaning of the terms.
I'd say a sloppy job in terms of having a contract that's clear and understandable and doesn't require flying me from British Columbia to sit here today to talk about what this might mean.
But who bears today, based on the facts, the flaws that you identified, the sloppiness that you identified?
The parties.
Why Belmont? Because when you opt out of the clear terms of the contract, you identify 3 reasons. All of them are adverse to the purchaser. And the case law then you cite says you have principles of unjust enrichment, and it adds, unjust enrichment is not a principle that you can use when to modify the bargain for, or I would understand the sloppiness.
The sloppiness affects both parties. I think today we find ourselves in a situation, I assume, where we're trying to say that Belmont owns the shares. I think if Belmont 8 years ago or 10 years ago was arguing that it should own the shares. It might not own the shares as a result of somebody then attacking this contract on, EuroGas saying it owns the shares, by attacking this contract on a variety of bases, with ambiguity, Section 6 being severable because it's a legal gambling contract on its face. Who knows, right? The ambiguity benefits no one. The ambiguity allows people to, yes, say what they want, take different positions from time to time, but it doesn't benefit any party.
Okay, identify a problem for Belmont. What would be the problem? It owns the shares, it keeps the shares, and it waits for performance. So why is it at risk?
It's at risk because the contract would be such that it's not entitled to receive $3 million in cash. It's entitled to receive exactly what it told its shareholders, which is additional shares. And it had a right to ask for those additional shares. And if it did or didn't, it either got additional shares or didn't get additional shares. But it's got no 57% in Rosman shares.
But
anymore.
meanwhile, it retains the shares.
In your interpretation, perhaps. In my interpretation, no.
Okay, let's go to that, at Article 6.1, it kindly looked at the SPA. I can identify the tab for you. It should be tab 57, R0107.
Yes, I'm there.
Okay. I like article at closing, okay?
Article 6, yes.
Okay, you agree with me that it addresses closing, right? This we can agree on, correct?
Yes, it's titled closing, yes.
So based on the facts that you have, not the facts that you have only in your first report, not only the facts you have in your second report, but the facts that you have today, did the transaction close?
Yes, I think so. All the evidence I have is that it closed. I don't have a piece of paper that specifies the closing date. I wasn't able to find that anywhere. But the only thing I could find is that the parties seem to have issued the shares and agreed a closing occurred on July 16th of 2001. And I based that on the financial statements of Belmont that suggest the shares, the 12 million shares it received had became tradable on July 16, 2002. So I'm assuming that's not a coincidence, that there's some sort of, without being U.S. law expert, some sort of 1-year hold period, and that's why they've identified July 16.
That's your assumption.
That's certainly an assumption, absolutely. And secondly, you typically, once again, who knows what rules were broken or bent, but typically you don't file and receive your TSX final approval on a transaction until it's closed. And the July 18th press release of Belmont said we've received our final approval of the TSXV.
Okay, so that's another assumption as well.
I'm assuming that things were done properly, yes. I'm saying that in the ordinary course, that final approval is not given until the closing has occurred.
How do you read the other correspondences that even in the financial statements that the shares are held in guarantee until realization, the term until realization is used, then the transaction to be completed, then the letters between counsel from different parties alleging breach. You recall that there is also a letter from Belmont saying we have the right, we will exercise our right to dispose of the shares.
There's lots of talk about foreclosure and all these things, and as I say, that's entirely consistent with the position that these shares were held as security for the post-closing obligations, which is exactly what my report says, and exactly what the financial statements say.
Did you see any request for closure?
Sorry?
Did you even see any request for closure?
For closure or for foreclosure?
Foreclosure, not foreclosure.
No, I did not see a request for
Okay.
closing this transaction.
Let's look at Article 6, if you don't mind, and let's go over it. There is a reference to the terms of the trust, so the shares being placed into trust, correct?
Hmm?
Were they placed into trust?
With a solicitor of Rosman, is that correct?
Yes.
I don't know.
Well, you don't want to ask whether it's not of interest to ask that? You try to find out?
I don't know that I'm allowed to phone up the witnesses and ask them what happened. I've given facts.
No, but they count, so you can.
Oh yeah, I asked for all the documents and the like, and I was told that there was no response that was available to me. Mr. Anway would know better than me, but I put together lists. He asked me, and I put together lists of
Okay.
requests, and
And
I
the
was
answer
told,
you got is
sorry.
what?
I was given a small subset of what I had asked for, and was told the rest was unavailable or did not exist or was not being produced.
No, but I'm not talking documentary evidence. I'm talking about did you ask whether there was a trust in place?
Yes, I asked for evidence of all these
Okay,
things.
and when you don't see it, that means what? Either one party is hiding, or it means that no. Does the fact that there was no trust here, the trust provision was not complied, does it change any of your conclusions?
Whether, to tell you the truth, no, because in my mind, I'm looking at this, as I told you, as a secured interest, and the way, certainly Slovakia law probably has some bearing on this, but the way you would perfect that security interest, both in British Columbia under a Personal Property Securities Act, as well as I understand, I'm no US lawyer, but under the UCC is by possession. And so whether you possess the shares yourself or have them in a trust or escrow held by a lawyer, that is security, or can be security. And that's the way I've interpreted this.
And what about the 100,000? I read in your first report that you assumed that it was not important, it was waived. That's
Or
you made
paid,
a-
yes.
You made an
Either
assumption.
paid or waived, I said.
So you're happy with that assumption?
Well, then your reply said, no, only 76 has been paid.
And you're happy?
And my reply to that said, well, the financial statements say it has been paid. 100,000 net, 96 recovery, 150,000 Canadian dollars. So when I look at the financial statements, not only do I see what I think is payment to the NRR, I'd love to get more facts, I also see a repricing of a warrant. And I have no idea what agreement was made between the parties as to why this warrant was repriced and that had a value of $100,000 or $200,000 in the financials.
Come back to your table, that was in one financial statement, that there were shares, there were valued placed in those shares, and there was a amount of 100,000, and there was an amount next to it. But weren't those projections?
Why don't we go to that document then?
Yeah, and I'd like to look at those financials, because I read it not as a
You
projection.
cited them, I'd be happy, but, and then, best of my recollection, it uses the word guarantee moreover down there.
Mr. Chairman, I would ask
Yes,
to
we
document you both the witnesses.
Have to wait until
Yeah,
the witness has seen
well,
it.
it is,
So there's a whole variety of financials, but I think the 2002, which is R0114,
it should be the same binder, because in the opening, I raised those, you know. If you go, it's in chronological order, so if you go back, you will see that probably. We'll find it for you.
I've got 114 at tab 17 of this binder. Oh, that's my binder, or your binder.
I'll answer. a site plan here. You guys. Maybe I'm wrong.
Is that 2002?
I'm looking at 2002
Okay,
and
sorry.
compared to 2001. And there's subsequent ones as well, but.
Well, you have
Where
it,
do we find that?
5A. It's 58, it's R0114. Are you there? You should have even a sticker.
Yes,
Do you have it?
yes.
Okay, so we're talking about R0114. Okay.
Correct.
Okay.
No, but this is just an extract. This isn't the full set of financials, because this transaction is both under significant accounting policies and under note 3, disposition of subsidiary.
Anyways, you mentioned this table, and I think you were referring, maybe I'm wrong, to this table, and for me, I see that as expectations not realized. And then in any event, there is settlement of the amount and guarantee. Then you go on to the next tabs, still doesn't matter, it says pending realization, and then the correspondences are self-explanatory. If you move with me to a final topic, is precisely the closure. So you mentioned in July 16th.
That's what I've been able to piece together, but I'd be happy to see additional evidence that suggests something else.
Okay, but that's on the assumption of the venture exchange, Canadian venture exchange
Final approval.
resolution of the deal, correct?
Final approval, yes.
Let's go back to the SBA, if you don't mind. It's 57. So Article 6 says, within 30 days of the approval by the Canadian Venture Exchange of the transactions described in this agreement, the vendor shall deliver in the trust, which you didn't do, the shares, okay?
Yes?
So the Canadian Venture Exchange, if you then move to tab 71, R0217,
Yes?
it says the annual general meeting of Belmont was approved on July 16th, correct?
Mm-hmm.
And then on July 18th, so that's what was the special resolution for the sale by Belmont, and then on July 18th, the Canadian Venture Exchange had accepted for filing the share purchase agreement. It's July 18th, correct?
That's the final approval, yes, that you file for and obtain after your transaction is completed.
So when could you close? What's the earliest day that it could have possibly closed, based on Article 6?
Well, there's an approval by the Canadian Venture Exchange on May 16th, the conditional approval, which is the approval you
Yes.
normally close on. So I guess the earliest date would have been July 16th, which is 30 days later. This transaction was also,
May? In May. 30 days later than May is...
oh, sorry, June 16th. My mistake. So June 16th is 30 days after May 16th. But this transaction, as you will know from the information circular sent to the Belmont shareholders to approve the transaction, identified this transaction as I'll colloquially call it a fundamental transaction, but it was a transaction that involved the sale of all or substantially all of the assets of Belmont. The information circular identifies as this 57% of Rosman is constituting 90% roughly of its assets. And so, as a corporate matter, this transaction could not be completed until that shareholder approval had been obtained, and that shareholder approval, as you pointed out in this exhibit, there's a press release saying that approval was obtained July 16th, and as far as I can tell, people closed immediately after receiving that.
Based on everything you just said, different assumptions in your interpretation, correct? It closed in July 16th.
That's the best I've been able to ascertain, because the July 18th final approval would not be given until it had closed.
Sorry, we'll have to make a break soon, so choose the
Okay,
right.
thank you very much, Mr. President. So, based on your assumptions, interpretations, you conclude that July 16th, 2001 is the closure date under Article 6.1.
That's the best I've been able to ascertain, yes, on
Okay.
the evidence I've seen.
Have you considered that on July 11th, I guess you have, because you've been sitting in the room now for some time, that EuroGas 1 was dissolved?
No, I'm not a US law person, so I haven't considered that.
Let me make an assumption. May I assume that you don't think that that changes your conclusions?
Someone will have to tell me whether it changes my conclusion.
Well, I'm asking you, objectively, you're here as a, quote, independent expert. And I'm asking you, as the independent expert that has been produced by respondent, whether or not you think that there could have been a closure on July 16th when the purchaser was a dissolved company since July 11th.
So I guess there's two answers to your question. The first answer is the factual answer, which is, did people actually issue shares? Did they do something to complete this transaction? All evidence points to yes. Indeed, the financial statements are replete with not only having received the shares, but having sold them and realized some amount of money. So did it happen? Yes. Was it legally authorized to happen? If that's the second part of your question, once again, I always hesitate to wander into areas I don't know anything about, but I heard people sitting here a little while ago say that you can do things within 2 years of the date you're dissolved, and those are, if you reinstate, are just fine actions. So I would have, once again, I'm treading into territory I'm not an expert in, but it sounds to me like it is
I think
authorized.
he should not be brought to that
I
territory.
understand. I'm going to a territory under Canadian law, Mr. President, if you allow me, okay?
So maybe that's the right time to break.
Okay, so, good.
15 minutes means until 10 to 4.
Thank you. dissolution
Yes,
that occurred on July 11th, I do not want to address the consequences in relation to Utah law, but in relation to Canadian law, how does that impact Article 4, the covenants, representation, and warranties? And it says the purchaser covenants, represents, and warrants to the vendor that now and at closing, it has the full authority to enter this agreement.
well, if I understood the Utah law correctly, Utah law permits, during the 2 years following dissolution, an entity to complete contracts and complete its obligations. That's what I heard Sam say. So this says to me that if that's true,
I think
this
he shouldn't be
representation
asked
is
this
true.
question because he doesn't know.
Okay, but I was trying to analyze this under Canadian law. The answer is that there is no, that this has to be viewed in conjunction with Utah law, which I
That's-
understand to
that's
be
correct.
understand. I'm happy to move on.
Yes, but on Utah law, I mean, he's not an expert.
Mr. President, I agree with you on that. I didn't ask what are the acts that a dissolved company can do under Utah law. I said, what is the impact on Canadian law? And the answer, based on the Article 4, he answers that it relates to Utah law. So once he gave me that answer, I move on to my next question.
But he says things on Utah law, which I think he tries to guess, but that's something.
No, that's why I said I completely agree with you. I'm moving on to my next question,
Okay.
because he linked that to Utah law. So once he pronounces that it depends on Utah law, I go to the next subject. What about the Canadian Venture Exchange approbation? Does the fact that the company is dissolved, the purchaser, has any impact on the approbation of the Canadian law? Or does that also relate to Utah law?
What do you mean by approbation?
Well, on July 16th, look at 6.1, it says within 30 days of the date of approval by the Canadian Venture Exchange of the transaction and described in this agreement. So, and there was a, on July 16th, the Canadian Venture Exchange approved the transaction.
Well, sorry, but on May 16th, I think we said the Canadian Venture Exchange gave its approval, and on July 18th, it gave its final approval.
Yes. Well, is there any consequence or a potential consequence on the validity under Canadian law of that resolution, final resolution?
Final approval of
Approval,
the
yes.
Canadian Venture Exchange?
Yes.
It depends, I imagine, on Utah law.
Okay. What
But
about,
just so you understand and it's clear, I haven't seen the approvals, but on May 16th, the stock exchange would review the